Ready?
May it please the court, counsel? This case involves a plea that was a mess from beginning to end. Trial counsel, the heart of our case is that trial counsel misinformed the defendant about the length of her probation, and therefore it should be reversed on that basis.
Right? That there was a problem with the plea?
Yes, I mean, it goes, what happens is that initially they made a plea for, she would do.
Forcible felony, they couldn't do the suspension, right? Okay, but that was known before sentencing?
Probation, or the parole?
Suspended, her sentence could not be suspended.
Or sentencing.
Found that out, she was given a chance to withdraw her plea, correct? Okay, can you help direct me? Is there anywhere in the record, is that being challenged, that she wasn't told she could withdraw her plea, or where are we on that?
She was told numerous times that she could withdraw the plea, even at her sentencing, when they redo the kind of reconfirmation, she was told she could withdraw her plea, but she didn't withdraw her plea. And part of that basis is she was told repeatedly, you know, she's eligible for immediate sentencing, but she's also told that the probation, or excuse me, parole, is 4.6 years is the average. And they're also talk about in the numerous letters that the trial attorney sends her is that she, they repeatedly say you're immediately eligible for parole. The county attorney is going to send a letter, went from 6 to 12 months, will send a letter in support of your parole. And so the idea is she's given the idea that it's not just that she's eligible for parole, but that she's going to be considered for parole within that first year. And
told that the average is 4.6 years, so she shouldn't really expect to get out in a year. That doesn't make sense.
you know, you're a great candidate for parole, and you know, things like that. So she's you know, average, you have good and bad, and she's way on the good side. So, and the county attorney
Told though that there's no guarantees.
told that, but she's still told that the average is 4.6 years, and after she's in prison, she finds out she's not going to get out for 15 years, at a minimum.
The lawyer relied on a legislative service, an LSA fiscal note, and the legislature itself relies on those fiscal notes. Was it a breach of duty for the lawyer to not investigate behind that 4.6 year estimate?
Breach of, I guess I would turn to the Tennessee case that I cite in my brief, where the court says they wouldn't find necessarily that there was a breach of duty, but the defendant was still, you know, misinformed, and so they reversed because the defendant was misinformed and prejudiced.
For defense counsel to claim ignorance about any knowledge that he or she has garnered throughout their career and just say, I have no idea, you're going to be sentenced to 50 years, I'm not going to make any guesses, your guess is as good as mine. Is that what we want lawyers to do?
Investigate. And so that's why, you know, I bring up the Tennessee case that, you know, you could say that he didn't breach his duty, but still she was misinformed, and so she should have her plea tossed.
Where is that Tennessee case decided?
I do not know off the top of my head.
1978, and here's why I ask. So Hill versus Lockhart is kind of the seminal case on ineffective assistance in the guilty plea context, correct? And that case actually involved the lawyer providing misinformation regarding the parole eligibility date. I think the lawyer told the client, you're eligible once you serve a third of your sentence, and maybe it was a half or 2/3, something like that. I can't remember exactly. So I know you cited some older cases, but after Hill versus Lockhart, don't we still have to do this in a two-part process, finding a breach of duty and prejudice. Those earlier cases seem to just say it's prejudice per se, and I think Hill changes that. Is that correct?
Prejudice here because, she relied on this and she pled guilty, and she's going to be doing much more time than she thought she would.
Not because he said that. And there didn't seem to be any indication she really would have gone to trial. She had a lot of reasons she gave to not want to go to trial.
True, but I mean, we don't look at what the results of a trial would be. We look at the fact that she's denied her right to a trial because she pled guilty.
Well, no, I think the burden is going to be on you and your client to show that if these, what you say were misrepresentations weren't made, she would have gone to trial. And the record strikes me, and you can correct me if I'm wrong, is really kind of silent on that particular issue. Try and convince me that had she been told what you see as the truth, that she would have taken the case to trial in any event.
She says in her, when we were talking about, when she's talking in the PCR about the being denied an in-person hearing, she says that she wouldn't have gone to trial if, her dad had been there and been able to say, don't do this.
That's kind of speculative. We don't know what her dad would have done or not done.
Word for it that she would have not gone to trial. I mean, it's clear that she wants to get out and be back home. Which I recognize everybody wants to get out and be back home, but I mean, that's her whole thought is being back with her family. And so, if you present.
A reduction in the charge, right, from murder one. They agreed to take that off the table. And also, I think there were some comments about keeping a lot of things out. I know there was that, we can get to that later, but that in chambers discussion, but talking about Pinterest and all the phone calls, and she just wanted to be done. Wasn't that pretty clear? You say we got to just take her for her word, but these are some of her words too, reasons why she wouldn't have gone to trial.
True, but I mean, those words were actually more the attorney's words, but her words are still that attributed by the attorney is that she wanted to be home, she wanted to be with the kids. I mean, she should have that opportunity to make that decision.
On to trial on this charge and been found guilty, would her sentence have been any different than the one that she ultimately got by pleading?
She still would have had a 50-year sentence.
Our trial judge made a finding that she would not have gone to trial, and that's after he heard her, her testimony and considered all her reasons and the lack of defense to, after she left her small child unattended for a half hour or so. Shouldn't we give that finding some deference and conclude there's prejudice was not proven here?
Reviews, so.
Wait to that credibility determination, can't we?
A little bit on the breach part of this analysis. So what did the attorney say that was actually incorrect?
Well, I mean, the reality is he said, your probation or the average time served before parole is 4.6 years, and that's incorrect.
The average time is?
Well, the ALJ says that she's not going to get out before 15 years.
With respect to the actual average.
We don't have that.
Anything in this record that would show the attorney's assertion that 4.6 years is the average, regardless of how much time she serves, is actually an incorrect statement?
Well, I think from the ALJ's statement, it's that somebody convicted of this crime, this type of crime, they're not going to get out before 15 years.
Then did the lawyer tell her, I learned 4.6 from this LSA document?
Say that.
Anybody disputing, like, did he lie about that number? Was it really 14.6? Or is there any evidence that that LSA document was just dead wrong, other than it's not out yet?
He did find that document, and that's, what he told her. I mean, apparently it is wrong because she's getting different information from the administrative law judge and from the counselors in the prison.
But doesn't Justice McDonald have a point? I mean, it's your burden to show that the information was inaccurate. The other information that was presented below is doesn't really disprove what the LSA document said. I suspect the LSA document is wrong, but it doesn't disprove it, does it?
Well, I think it does. I mean, we're getting information from the people that, work in this area. So, I mean, I don't know where the LSA document gets its figures, but
Say that a lawyer breached constitutional duty of representation by telling the client truthful information or information published in a government document used to advise the legislature on the average length of a sentence served. I mean, how would it help us? How would we write an opinion that says that that is a constitutional violation to rely on government documents for information?
And if we did that, wouldn't that have a chilling effect on lawyers giving any advice on what they think might happen?
well, that's why, I mean, I understand that you think Hill now overrules essentially the Tennessee case, but I think there's an option here for the court to say, well, okay, he didn't necessarily breach his duty, but this person made a reliance on information that's not accurate in coming to her plea. She was counseled in a manner that is not accurate, and so we need to give her some relief. The other issue that is raised here is that counsel was ineffective for not making sure that defendant was willing to waive her right to a public hearing. And in this present case, no one asked her whether she wanted to waive her right to a public hearing. The court never inquired whether she wanted to waive her right to a public hearing. And defendant submits that this was a breach of duty, and again, that she was prejudiced on her words that she...
That was a breach of duty, but I also think we ought to apply the Weaver case from the U.S. Supreme Court that if you don't object at the time when the trial court could resolve it, then okay, let's move into the chambers where the reporters are out there if that's what you want. But to show prejudice, I mean, if we follow Weaver and require a showing of prejudice, what was the prejudice?
Here's the fact that, she asserts that she would not have pled guilty because, she would have had, her family and everyone there to support her.
It does seem like if we rule for you, then what's going to happen is in the prisons of Iowa, we're going to hear about all these guilty pleas that were entered 20, 30 years ago that turned out were in chambers and that the person, I mean, don't you think on a PCR at this stage you have to show some prejudice? This isn't a motion to set aside the plea, a motion and arrest or judgment.
There's some sympathy for that in that, Justice Kennedy, he was very concerned about the amount of time that elapsed. I believe that case was 2000. The shooting took place in 2003, but the hearing was, or the decision was in 2017. So there was a long lapse of time, but we don't have that here. We just have a few years, and memories are fresh, and And this is her first opportunity to raise the issue because she's been sitting in prison and now everything is starting to come to light. But I see my time is up, and so for the reasons stated here and in our brief, we respectfully request the court to vacate her guilty plea.
May it please the court? I want to start off talking about Hill versus Lockhart and the prejudice standard, because I don't think you have to look that far back to find an answer. This court had the debate over what the standard of prejudice should be for guilty pleas. It was in Strawn and Kress, and the resolution of that issue in Straw was to expressly adopt Hill versus Lockhart. I don't think that question is reasonably in front of the court today. That's settled precedent. Under the precedent is the defendant's burden to prove essentially that she would have insisted on a trial rather than enter a guilty plea in order to obtain relief. That assumes breach happened. If we assume that, she still falls short. The district court didn't use magic words like, I find the defendant's story not credible, but what you see in the ruling is an implicit credibility finding. She gives some reasons why she would have wanted the guilty plea. She asserts at one point, without really a whole lot of explanation, that I wouldn't have pled guilty.
Have to lose by rolling the dice and going to trial if what she pled to got her exactly what she would have gotten had she gone to trial?
I think sets aside what happened before the charging documents were filed. Murder one was on the table in this case. If you look at the minutes, this is a winnable first-degree murder. She was on Pinterest while her child drowned in the bathtub. As a pre-charge concession, the state moved to the child endangerment resulting in death charge. No minimum whatsoever.
What am I to make of the fact that the prosecutor was going to agree to 6 months, apparently? If this is really a murder one case, what do I make of that fact?
That question isn't in the record. I think we can make some speculation that perhaps he was worried she would be sympathetic. You know, the very crass parlance you sometimes hear is the mommy murder discount, and that reflects that in Iowa it is difficult to convict mothers of killing their children. This is something that prosecutors run into. That probably was a concern for the county attorney.
Sentencing here, didn't the county attorney say that this was an accident?
He's negotiated this and embraced some version of her story. Yes, and of course he was bound to do that under this court's case law. He had to zealously advocate for the deal. Had he not done so, had he shown some kind of reservation, we'd be here on a breach of the plea agreement claim.
In the record that anybody was thinking about murder one at that point in time?
Letters indicate between Mr. Chaplin and Mr. Bull, the county attorney, that it was part of the charging concession made. The state wouldn't go forward with the murder one charge because they were going to engage in this plea. I guess there's not an explanation of exactly what the county attorney was thinking, but that also doesn't surprise me. I certainly wouldn't put that in a letter to the defense.
I mean, it strikes me as what she pled to, which is Justice McDermott's point. I mean, what else did she gain? What besides this charging concession?
What she gained was essentially not having all of this dirty laundry aired out in front of everybody. There's a mention from Mr. Chaplin that she wanted to get a quick resolution to have her children reunited with her husband. I think that's a reasonable thing for a mother to be interested in negotiating a plea. There's discussion about how she wouldn't have to look at the autopsy photos at trial if she engaged in the plea. Again, I think that's a reasonable consideration for a mother under the circumstances. But I'm not sure second-guessing her choices is even in front of the court at this point, because she was expressly and repeatedly given the option to withdraw her plea, to file that motion in arrest of judgment by the
But afterwards, it seems to me, she had the, and maybe it's only an impression, and that might support your argument, but she had the impression that she had a chance of what I'll call a quick release. She had a chance of a quick release because the prosecutor was going to write a letter and the prison authorities were going to, she had this vision, and it could only be a chance because she was very clearly told there were no guarantees. But she had the vision that there was a chance, if she played along nice and pled and so forth, the prosecutor writes a letter, there's a chance she could get out in a year or thereabouts. And I don't know that that was true. I mean, I think, maybe she unreasonably believed that, but it seems to me she had a wrong impression. And then the question is, well, was that because of the communications with her lawyer who wasn't clear enough?
There, the first is, I don't think she had a wrong impression. Statutorily, she was eligible for parole. That's what she was told. That is true. As a practical matter, how likely is it? Not likely. I think everybody agrees on that. But the second part of my answer is that the Constitution doesn't protect a defendant's unrealistic hopes and dreams. Did she hope she would get out fast? Yeah, absolutely. So does every defendant headed to prison without a mandatory minimum. There is...
Her lawyer foster that in a pretty aggressive way. I mean, we have all these letters where he keeps saying you'll be out in 6 months, right? This average of 4.6 years, you're on the good side of that average. I mean, could she realistically have thought it's actually going to be closer to 16, best case, instead of what she actually has?
One of the factual premises in your question, which is I don't think she was promised that she would be out in 6 months. I don't think the record bears that out. Did he tell her the 4.6 number? Yes, and I want to sort of pivot to that for just a minute because I think there's some confusion there. I think that is a realistic number. I think that is the average that's computed. I think it's from the Board of Parole Statistics. That's where LSA got it from. This is a crime without a mandatory minimum, and every prosecutor and defense attorney in the state knows that you're not going to do anywhere near the time that's on the upper end of that range, unless you're the unusual offender who misbehaves in prison, who has disciplinary trouble. I think the statement to the defendant in this case that she was a good candidate for parole is probably a true one. I don't know of any disciplinary problems that she has. Certainly from what we have in the record, she doesn't seem likely to be starting fights at prison, refusing to do the coursework, anything like that. She is a good candidate, and it's just barely been that 4.6 average. And of course, and I don't mean to sound like I'm talking down, but an average means half or more and half or less. She may be above the average on the 4.6. She'll get out at some point. Nobody made any promises to her that she'd be walking in the door and back out. If that had happened, if somebody had said, Ms. Sothman, in 6 months you'll be back with your home and I guarantee it, that'd be a different case. And I admit that, but that's not what we're talking about here. There was confusion, as there often is on complex felonies, about what exactly the sentencing parameters were. Would it be better if nobody had given her some misadvice? Yeah, absolutely. But trial work's messy. This happens. As soon as everybody knew the error.
For you on the charging concession issue, am I wrong, or is my recollection wrong? I thought there was discussion of, in addition to murder in the first degree, that she could be charged with a different B felony, endangerment, that had a mandatory minimum. Am I misremembering that?
Child endangerment alternative, which is a felonious assault and in some circumstances could qualify. There was also talk of the neglect of a dependent person charge. I don't know if at that time it carried a mandatory minimum, but at least one of the charges in the mix did. And of course, murder is life without parole.
Minimum at that time, is that right? Okay.
Further on the charging, I know it's the county attorney's prerogative to choose the appropriate charge for the trial information, but the actual original complaint by law enforcement was child endangerment death, correct? So the cops didn't initially charge her with murder in their complaint?
Well aware that it's not unusual to see a complaint with one charge and a trial information with another.
Argue that murder was very realistic. You had to get there even after the initial complaint, because complaints are typically pretty close to the spot, wouldn't you say, to what gets filed?
Diplomatic answer of I think it varies by law enforcement jurisdiction.
Decision, and I think they're more on the mark than they're not.
I think if we're going to try to read the tea leaves, I agree with you, the complaint maybe weighs in favor of the defendant's argument. But I'm not sure we need to do any tea leaf reading. She was given chance after chance to withdraw this plea. Eyes wide open. I mean, Judge Mertz's colloquy with her, the one that occurred in chambers, she really tries to just painstakingly explain this to her. You know there are no guarantees. You know that it is up to the board to make this decision. That's about as clear as an explanation you get. The defense has talked some today.
Chambers too. I've read that, and I broke down the, and it looks like there's about 13 and a half pages of in-chamber discussion, and there's out in the courtroom. I'm not so persuaded that it was an automatic violation by the lawyer. Isn't that kind of going back? I mean, it was almost like the pre-sentencing sentencing and kind of going over the guilty plea again. But was there anything that happened there that, as far as necessity of sentencing that should have happened or didn't happen out in open court?
I think part of what your question gets at is we've all sort of struggled with the vocabulary of what do you call this thing. In my brief, I talk about it as part of the plea hearing. The Court of Appeals talks about it as the first half of sentencing, but I don't think that's quite right because it's not a sentencing hearing. The closest descriptions, it's like a confirmation of the guilty plea. And I think if you read what Judge Mertz said, that's what she's trying to do. She's being really cautious. She's trying to make absolutely sure that the defendant is committed to this plea, to give her the opportunity, even if she'd missed the deadline, to file that motion in arrest, which, by the way, the state said they would not resist. And the defendant's very clear, no, I want to keep this guilty plea. I want to be sentenced today. So I don't think there's anything about that colloquy, whatever we're going to call it, that is actually part of sentencing. It's like a second confirmation of the guilty plea.
Heard. I looked at it, and then we're back out on the record. It says the matter before the court at this time is the state of Iowa versus Sothman. We're here today, criminal number such and such, personally present and represented by the attorney. Is the state ready to proceed to sentencing?
I don't think it is a sentencing hearing that happened back in chambers. It's a confirmation of a guilty plea. I think there's some thorny questions about how that fits into our prejudice analysis, but you don't need to get to those because of Weaver. Of course, if we're talking about federal law, Weaver's controlling. If we're talking about the state constitution, I'm just genuinely not sure what the defendant's arguing for, other than I know she wants to win this case and get her guilty plea set aside, but there's no...
There's dissent in Weaver. Does she not? I mean, that's kind of it.
Dissent even gets her where she needs to go, because the thrust of the dissent is structural error, but the dissent doesn't get into that preservation issue. The dissent just kind of says, well, whatever it is, raised it or not, we're going to treat it the same. But that's not ever been the law in Iowa. Of course, error preservation all the way back to the 1850s. The equities really are quite a bit different. Here we are 6 years later. Putting together a retrial on this case is not as easy today as it would have been at the time that she was given the opportunity repeatedly to withdraw that plea. I think the majority in Weaver is correct that the finality interest of the state really is quite a bit different. One interesting thing the dissent talks about is this sort of ephemeral interest the public has in the public trial right, and what do you do to ensure that's vindicated? Obviously, the state believes that is an important interest, but courts have to weigh interests all the time. And here, the finality of that conviction, particularly on these facts where the defendant is given the chance again and again to withdraw that plea, that outweighs the broader public interest. And it's not like this is a secret hearing that was never documented and nobody ever found out about it. It was transcribed by the court reporter. It was filed on the docket as a transcript. It's in public records today.
But I mean, all that's true. But there's a lot of cases that deal with constitutional violations that were made part of the record and so forth. I mean, your stronger point maybe is that what was this animal exactly? I mean, it wasn't a mini trial. There wasn't fact-finding going on. There weren't court rulings, really, although one might challenge that. But I think you're right that this isn't quite as protean as some of the other cases in terms of its importance to the trial. But, yeah, go ahead.
I think there is something to the notion that what we're really talking about for a structural error with the public trial right is a trial. The reality is, especially rural practice in Iowa, there are a lot of hearings that happen outside of the main courtroom. I, of course, try to get a waiver, but nobody's perfect. I'm sure if the county attorney could go back in time, he'd say, I wish we'd done a waiver in this one too. But the reality is you do a lot of work in chambers, and if the rule is going to be that every interaction with the judge has got to be in open court, I think we're going to have real logistic problems in our courtrooms. If this was a trial where we had shut everybody out for the duration, I think this is a different story. And some of that analysis...
Evidence is, absent some compelling interest would be problematic, it seems to me.
Range, right? And the further you move toward a full-blown trial, the more problematic it is. This thing is way over here, away from the trial piece. This is about as far from a trial as you can get. There's no evidence. It's a colloquy with the judge trying to make sure that the defendant understands the choice that she's made. After the full-blown 2.82b colloquy, Judge Mertz is going above and beyond, doing her best to make sure this thing is not going to come back to bite her. And of course, here we are despite her best efforts.
Would you agree she had a right to conduct that proceeding in public?
Chambers, whatever it might have been, a statutory right, I would concede. I'm not sure about a constitutional right. There, in my research, just isn't a case that's exactly on point with this sort of unique monster of a hearing. Sentencing in Iowa, certainly by statute, has to be conducted in open court, probably under the Constitution does, but this wasn't a sentencing hearing. This was a colloquy with the judge.
What would be the consequences if we said this proceeding, structural error, automatic do-over? To follow up on Justice Mansfield's concern, would we see a wave of new PCRs?
To my earlier point, I'm not sure I can think of a criminal case. I see my time is expired, if I could wrap up. I'm not sure I have personally handled a case in criminal court where there hasn't been some interaction in chambers outside of the public courtroom. Is it a full-blown colloquy like this? Sometimes yes, sometimes no. Potentially every single criminal verdict in this state is endangered by such a rule because the nature of the beast is that you're going to have conversation with the judge in chambers. If every interaction with the judge has got to be in open court and reported or it's structural error, I worry about, and this isn't me being hyperbolic, quite literally every criminal conviction.
Time a little bit here. I was just looking at the transcript of what happened actually in the courtroom after there was the colloquy. And I do agree with you, that's pretty standard to have conversations with the court, especially on the record. And many times it's the request of the defendant, but to do it that way. But actually in the courtroom, I'm just looking through to make sure that everything was there. And what was discussed in chambers, correct me if I'm wrong, was addressed in the open court too, such as we negotiated the plea, this is her attorney, that brings us to court today and on August 5th, and then right before he gets done, we're asking the court to approve the plea agreement and sentence. This is our agreement. It's been accurately stated, and we believe it's a fair and appropriate sentence. So help me understand, is there anything, is there anything in the record that they're alleging should have happened during that sentencing that didn't?
If you look at the statute, everything that's required of a sentencing took place in open court.
It was bootstrapped, maybe.
There's part of the confusion is should the court reporter put it into transcripts, would be having a different conversation then. Again, this is sort of an unusual piece. Whatever it is, Your Honor, it wasn't part of the sentencing hearing. Thank you.
Yes, I want to talk about first the hearing in out of the public presence. She's placed under oath. She's has direct and cross-examination about what her understanding is. And once she does this, now she's married to, you know, yes, I understand. I want to go through the plea. So, you know,
Sentenced in chambers, correct? Discussion. I'm looking at it here. I just can't see any of the magic sentencing. It just seems precursor conversation.
because she's placed under oath and she's questioned, you know, by the attorneys. So I,
Claim that she got locked in a private setting. But it probably, I mean, how can you show that she was in fact locked in? I mean, I understand she testified under oath and so forth, but how can you show that that was material? I mean,
it just her testimony, I mean, that's how, she doesn't say I felt locked in, but she says she would have never made that final decision had she had the family with her, particularly her father. And
Happening without the judge, but the judge allowing the court reporter to be used for a confidential conversation between the attorney and his client to verify the plea before sentencing. Have you ever heard of a situation like that? It's just like this, but remove the judge from the environment and the prosecutor too. Would that be anything similar? That it's a common practice to make sure that this person wants to go through with their plea?
it's different because you don't have the judge there. You know, because the judge then says, we're ready. I mean, if the client had said, no, I
Did she?
remember exactly what the judge said on,
Well, I don't want to put words in her mouth. I mean, I don't think that she said that.
but if the client has,
Thank you. I'm going to close the record.
Okay. So if the client, though, had said, I don't want to continue, the judge would have stopped it. And so, I mean, that is the difference. I think it's interesting that Mr. Buller talks about he always gets a waiver. Well, why does he get a waiver? Because he knows that's the right thing to do. We are in sort of this predicament that's addressed by Justice Breyer when we're asked to prove the unprovable because, you know, clients, they say they wouldn't have pled guilty, but how, you know, we prove one way or the other. And really what it goes to is, again, the structure of the the structure of the plea. As I said, we believe this is a supplement to the plea, and it should have been in public. There was discussion about the defendant would have been charged with first-degree murder. It's not unusual for prosecutors to overcharge the, you know, in this case, you know, again, probably the appropriate charge was the child endangerment charge. Like I said, they overcharge generally because they want to encourage pleas. The Constitution doesn't, the state talks about the Constitution.
Exposure for other child endangerment charges, either involving her other two small children and what exposure did she have?
Sentencing exposure would have been on those. There's
Mandatory minimum.
Yes, the Constitution doesn't have or doesn't protect unrealistic dreams that the state, as the state said, but they do protect defendants in making sure they have a knowing and voluntary plea. I see my time is about up. Defendant respectfully requests this court to vacate her sentence and remand for continued proceedings.
Case of Sothman versus State is hereby submitted. And if I didn't say it before, State versus Watson is submitted without oral argument, and the court is adjourned for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.